Hi there and welcome. This is the Disability Law Show. Thank you so much for joining us over the next hour. Lots to discuss. John Scholes here. Beside me, of course, James Fireman, Sivan Tumarkin from Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. On the show in just a bit, we'll get to this topic. 3 fast facts about chronic pain and LTD. We'll get to some emails from the email address, which I'm going to give you in a moment, and the website mydisabilityquestions.com, which is another place for you freely and anonymously to ask questions, so you can do that. But that email address, help@disabilityrights.ca. And any time outside the hour of the show, you want to talk to these two gentlemen on the phone, 1-855-821-5900. We'll keep giving that contact information throughout the hour, guys. But let's get to it. Before our topic, we always get to the success story, the story of the day, I guess you could call it. Van, what do you got, pal?
Well, John, it's been extremely busy over the last few weeks. We've been getting calls and emails from people across the country, not just Ontario, BC, and Alberta, where we typically work, but other provinces too. And let me tell you about an interesting call that I had from someone in Nova Scotia, actually. And this person is in his early 50s, is a father of 2, married, 2 kids under 10. And this person is works as an engineer, senior engineer. Now, unfortunately, he's been battling cancer for quite a while. And despite that, he's the kind of person who goes in and day out, goes to work, does his thing, doesn't want to, doesn't want to take time off, doesn't want to disappoint anybody, very hard worker. And so he's been working through his illness, his chemotherapy and everything else he's been getting, and progressively things have been getting worse. Unfortunately, it's gotten worse to the point where his employer had let him go as a result of performance issues. And of course, afterwards, this person applied for long-term disability. He had coverage through his work. The problem is that now the insurance company is taking the position that, of course, he's not actively at work. There's a provision in the policy that requires him to be actively at work. And besides that, he's no longer at his job. And so they're taking the position that he's disabled now post-employment. And that's something that we do see from time to time. And it does come up. And of course, the insurance company takes that position, and people oftentimes say, okay, well then I am too late in applying, there's nothing I can do. Luckily, one of his relatives in BC saw our program and told him to give us a call, and so I spoke with him and I explained to him that, if we look at the medical documents, if we spoke to your doctors, if we looked at everything, will the doctors say that you became disabled during the time of your employment, while you were employed? And the reality is, think about this from a common sense standpoint, yes, of course he was. That's the reason why he stopped work, or he wasn't able to fulfill his duties. So with the help of his doctors, we can, of course, establish that his disability arose while he was still employed. And we can go after this company, the insurance company, and force them to pay him the long-term disability that he is owed. It's a good thing that he didn't do what he was inclined to do, which is simply to just walk into the sunset, because it's not only the long-term disability benefits he's entitled to, but also severance, and potentially significant severance. He's been in this company for over 20 years. And of course, at our firm, we have employment lawyers and disability lawyers. And so we can help both on the disability side of things, as well as on the employment side of things. And who knows, if the employer was aware of his illness, which I suspect they were, they let go of somebody who was under disability. There may be human rights damages here. And of course, all of these modes of compensation interplay, and they're linked. So really, really important to understand that if at any point you apply for long-term disability and you get denied, call us immediately, because even if you think that you're not entitled to long-term disability, we may be giving you a different answer, a good answer, a positive answer, that we can get the insurance company to pay you something that you are in fact owed.
James, what's your take, pal?
Well, so that's what we would think of as a technical denial.
Okay.
It's not a situation where the insurer is saying that you're not disabled. They're saying that you don't have coverage, or perhaps there's a pre-existing exclusion. All of these things where the insurer avoids paying benefits without actually doing the analysis as to whether you're medically disabled. We think of those usually as technical denials. Sometimes they're right, but sometimes they're not. And typically, they're usually something that we're able to give our take on pretty quickly. It's usually something where we can look at a few documents and get a good sense as to whether the insurer is correct in taking that position. And so it's very easy to give us a call and to get our opinion and to see whether or not it is worth taking the next step. For a situation like this, the one that Sivan was just talking about, it may well be not so easy to make that determination depending on how disabled the person was in the days, weeks, and months leading up to them actually getting terminated from their position. But there are many situations where people are still at work, as Sivan was saying, but are under the policy actually disabled from work, where the employer is making significant accommodations in order to try and be a good employer, to try and help the person along. And because of that, they're doing a fraction of what they had been doing before, when anybody objectively looking at what they're doing would recognize that they cannot do the job they're supposed to be doing. Those people are certainly disabled. It's a spectrum, though. And you could be anywhere on that spectrum, and as long as there is at least an argument that you were disabled before you lost your employment, then there is exposure for the insurance company. And when there's exposure for the insurance company, they come to the table. And that's really important to understand. So if you are in that situation, don't give up, because there is much more often than not going to be the possibility that we're going to be able to help, we're going to be able to get the insurer to come to the table and to pay what you're entitled to.
Savannah, would this be a situation where the insurance company just kind of casts a wide net and says, they're not going to fight it, but once you guys step in, hold their feet to the fire, they're, oh, we're just kidding, no, we'll, you know what I mean? Like, are they going to step up at that point?
It's very possible.
Do they do that with everybody?
You know, John, it's very possible that if we produce a letter working with this person's doctors that establishes unequivocally that really he became disabled at a period of time when he was in fact insured, that the insurance company is not going to have a leg to stand on. Now, keep in mind, James is talking about the technical denial. I agree completely. That's what they've done. They haven't even given him an answer as to whether or not they believe that he's totally disabled. Although, again, remember, he's suffering from cancer. He's going through chemo. I mean, for them to take the position down the road that we're not just relying on a technical denial, but we're relying on a more substantial denial, or you know, they're going to focus on the meat of it, which is they're going to say that he's not in fact disabled. I think at that point they're going to open themselves up to punitive damages. In other words, we can go after them for a lot more than what otherwise they would have to pay.
It's not unrelated. You know, they get the application and they see that this is someone suffering from cancer, and they know if they approve the claim, they're on the hook. So the first thing they're doing is looking for any justification to get out from under that. And technical justifications work just fine as far as they're concerned. Wow. So they're looking for any reason. It doesn't mean it's a good one.
John, one last thing I want to mention, which is this. Unlike with the regular types of denials that we see, where the insurance company says, we don't think you're disabled enough, and the person says, no, I am disabled, my doctor says I'm disabled, people know, you know, if they are disabled or not. With a technical denial, I think a lot more people would simply assume that because the insurance company is technically correct, they can't get any benefits. And what we tell people is, look, it doesn't cost anything to speak to a member of our team. We can tell you within minutes on the phone, oftentimes within minutes, maybe by looking at some documents, whether or not you in fact have a case. And don't assume that just because the insurance company appears to be correct, that disentitles you from benefits, because oftentimes there are ways around it, and the technical denial the insurance company is relying on is in fact not a foundational denial, or not a denial that they can in fact sustain if this thing went further.
I'm going to throw one more thing out there that I think is important and might apply to a few people watching at home. So there are many people over the past few years who have been on leave from work because of COVID-19. And it is what is generally thought of as an IDEL, an infectious disease employment leave. And if that is the case, if you are on leave because of COVID, if your employer has said that you should not be coming in because of COVID, we're shutting down, or whatever the situation is, it has been my experience that when faced with that, insurers are required to extend coverage through that as long as the premiums are continued. So if you're in that situation, I would implore you to continue paying premiums. And if you do happen to have a disability while you're on leave because of COVID, then you're going to be entitled to benefits.
Again, guys, anytime to reach out to Sivan or James or the respective teams, 1-855-821-5900. Sivan, you did mention the employment half of the firm, and there's a website, pocketemploymentlawyer.ca. It's generally the creature of the Employment Law Show, but the reason we bring it up here, and I know James will talk about it, how it's been useful to him, is there's a section in there that deals with disability, correct, James?
Yeah, absolutely. So the Pocket Employment Lawyer is a tool that you can access online completely anonymously. And I think that's really critical, because even though we are inviting everyone to call us if you have a question without any obligation, I understand, and we understand, that people do want to get access to information on their own, initially at least, and just get a better understanding of what their situation is and whether or not they have a good case. And that is exactly what the pocket employment lawyer does, both for employment cases and for disability. And so on the disability side, you put in just a few brief answers to some questions. You don't have to put your name or email on there. Again, it's completely anonymous. And you'll get a very quick response as to whether or not you have the basis for a valid claim. And then if you do, and you would like to take it a step further, then there are instructions on how to get a hold of us, how to set up a consultation, which you can do or not do on your own time.
Yep.
But the key thing here is it is free information, and it's going to be very helpful for people to understand exactly whether or not they are going to have the possibility of a claim.
Again, can be found, pocketemploymentlawyer.ca is how you search that. But I want to get to an email here, guys, before the break. Anytime you can send those along, help@disabilityrights.ca. Rachel, first one, says, I've had depression and anxiety for most of my adult life, but the pandemic made it worse. I started having frequent panic attacks and eventually stopped working and went on LTD. Now the insurance company's case manager is being difficult, almost dismissive of my condition, and pressuring me to go back when I'm not ready. What should I do?
This is unfortunately something we do see frequently, where you have different case managers, adjusters who sometimes take very aggressive or assertive positions against the insureds. Remember that the insurance company has a duty to treat you fairly and reasonably. And you know, oftentimes when people feel this way, they do give us a call and they ask us, what should we do? And you know, the advice we give is fairly standard, which is as follows. Number one, make sure that you have your doctor's support, that you have, you know, your doctors have your back. You want to make sure that you have up-to-date letters from your doctors. I'm not saying get support every week, go to your doctor and bother them every week, but every so often make sure that you do get updates from your doctors, the treating doctors, with respect to your ongoing illness or injury and how that affects your work and inability to work. Make sure you provide that. Make sure you follow the recommended treatments. Make sure that you confirm all communications with the adjuster in writing. Now, Rachel, this is something that's very, very specific to you. There's nothing wrong with you not only confirming things in writing, but even stating to the adjuster that you would like henceforth all communications to be in writing, because speaking with that person by phone aggravates your condition, makes you more anxious, aggravates your illness, whatever it is. And make sure you speak to your doctors about what's happening with your adjuster, and that these communications and interactions with your adjuster are in fact aggravating your condition. For every step forward, you take two steps backwards because of the adjuster's conduct. Again, it's important because then it's memorialized within the notes and clinical notes and records of the doctors treating you. And the last thing I will say is this: your insurance company cannot force you to go back to work before you are ready and before your doctors say you are ready. And when I say that they can't force you, it means nobody's going to come to your home, put a gun to your head and say go. What the adjuster may do is continue to bother you about that, to which again you can reply by saying, no, I'm still not well, and I'm not going to go before I get clearance from my doctors, and then you give your doctors updates. And number two, if the insurance company at any point tells you that they're going to cut off your benefits unless you try to go back to work, and this is against medical advice here, your doctors don't agree with this, you contact us back immediately. We will help you. We will intervene. We will get in there. We will then push back against the insurance company. Remember, if the insurance company gives you a date for a cutoff of your benefits and says you are going to be cut off benefits by so-and-so date, and they should not have done that, meaning you're still disabled, they are in breach of their obligations under the policy, which means that you now have a legal right that you can enforce, that we can help you with. So again, John, the important thing is that people are already in distress. They're already ill. They can't work. Psychologically, this is massive for them. We see this a lot with psychological types of illnesses and conditions. This is where we come in. We take that pressure off because we're the ones that are going to assume communications with the insurance company so that the person, this disabled individual, has time to now get better, get well, and hopefully eventually get back to work.
What you should know if you suffer from chronic pain, that is coming up in a moment, but we'll take a short break. In the meantime, here's the reach out for contact. It's 1-855-821-5900, help@disabilityrights.ca. We'll continue. Stay with us. Lots more disability law shows coming up. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, thank you so much for sticking around here on the Disability Law Show. John Scholes, James Fireman, Sivan Tumarkin. Reach out to these guys anytime. Always ready to have that chat. 1-855-821-5900. Help at disabilityrights.ca. That's the email address. Guys, let's get into this. 3 fast facts, what you should know about chronic pain. Number 1, I'll throw this to you, James. Chronic pain is any pain that persists for 6 months or more and can cause an inability to work.
Sure, and it almost always is going to start with a physical injury, not 100% of the time, but what we typically see is that there is an initial physical injury. Usually, more often than not, it's easy to understand what that initial injury is, but then the pain winds up persisting for longer than one would expect for that initial injury. So, you know, you have a broken arm, let's say, or let's say a back injury, and there's, you know, a treatment on there, and the treatment typically would resolve the issue in 2 months, but then 6 months, 8 months down the road, it's still painful. That happens. It's going to happen a certain percentage of the time. It may well be that far more often than not, people are going to resolve, particularly people who are younger, who are healthier, who are in better shape. They may resolve their injuries more quickly, and then there's a segment of the population that simply won't. And sometimes it's even going to be the healthy or the seemingly healthy part of the population. It's not always easy to predict. But the point is, it winds up being a situation where pain from an initial injury winds up becoming almost ingrained. So I don't want to delve into too much of the medical side of it, but it actually does become something that's recognized as a mental health disorder, and it's recognized under the DSM-5, which is often used by psychologists and psychiatrists to categorize mental health issues. The name changes. It's, you know, sometimes referred to as chronic pain or somatic symptom disorder, but we're talking about the same thing here. Right. We're talking about a condition where they may not be able to actually see what the issue is anymore on medical imaging or what have you, but you still have pain that's persisting for an extended period of time. That is recognized at law as compensable, both in terms of a personal injury situation if someone were to injure you, but also for long-term disability. Chronic pain is absolutely a basis to bring a long-term disability claim. So if this is something that you're suffering from, if you are suffering from chronic pain that is sufficient, that it is preventing you from being able to function in your job, then you're entitled to long-term disability benefits.
That description lays the groundwork nicely for number 2. Sivan, I'll give this one to you. That is, many chronic pain conditions cannot be established with objective medical evidence and are considered invisible illnesses. What does that mean? Yeah,
we use the word invisible or the phrase invisible illness to describe those illnesses or injuries that you simply can't see with medical equipment, medical imaging. Look, when's the last time that you had an objective imaging, an x-ray or an MRI of your headache, right, or a backache or a chronic neck pain or whatever, anything that's, you know, in your joints? The reality is that there are many pains, illnesses, and just look at psychological conditions. I mean, you can't see those on an x-ray. It's just not done. So it's absolutely stupid for insurance companies to insist on those kinds of objective medical tests or evidence, as they call it. Here's the problem, though. We live in a world where people say, show me the evidence, you know, show me the money, show me exactly, prove it. And the problem here is that when people hear that, they think, okay, well, how am I going to prove that? Well, you don't have to prove it the way that they're saying you need to prove it. In other words, there's different ways of proving it. One way to prove it is to simply have your doctors, treating doctors who've been treating you and have been dealing with this and prescribing medications and treatments, provide a report that says this is our assessment. This is what this person is complaining of. This is what we've recommended, and they're doing it, etc. And so when we're talking about a chronic pain condition, especially a pain or a psychological issue that you cannot see objectively, and if the insurance company seizes on that and says you have no objective medical evidence, I can tell you almost outright, almost in every case, the insurance company is trying to pull the wool over your eyes, because the reality is they cannot deny on that basis. And when they try that with us, they hit a wall. So don't simply assume that they're correct. If in fact the insurance company has denied your claim or telling you they're going to cut off your benefits because there's no objective medical findings or objective proof or evidence like that, and your doctors are supporting you, they're saying you're disabled, you cannot work, you come to us immediately, you speak with us, we'll tell you what needs to be done right now, and trust me, there are going to be options.
It's interesting too, because I've seen through friends of mine who are doctors and chiros that you'll take two, lower back x-rays, one person's in excruciating pain, there's no physical evidence to be seen, but the next one's like, whoa, this guy's got a killer bulging disc, but he's not suffering from it. So you can't tell just based on that imaging, to your point.
Yeah,
to your point.
The orthopedic experts that I've used in trials before have consistently told me that medical imaging, even medical imaging that can show, for instance, arthritis, is not going to be able to predict with any degree of accuracy the extent of functional limitation. They'll see medical imaging that will show very significant findings where the person is walking around without any pain, and the exact opposite will also happen as well too. One of the very interesting words that is brought up in this conversation is the word objective. When you hear an insurance company say to you that there isn't objective medical evidence, immediately I'm going to tell you that there's a basis to challenge their denial, because they are not entitled to deny a claim on the basis that there's a lack of objective evidence. And it's for exactly the reasons we're talking about. The lack of objective medical evidence is very often a function of medical science advancements in the time we're living in.
Right.
If you go back before medical imaging, how would you show objective medical evidence of a broken bone? Right? Unless it's sticking through the skin, it's really not something that's going to be available. Yeah. And 20 years from now, 15 years from now, there very, very well may be plenty of ways to get objective medical evidence of chronic pain, to be able to show on a minute scale the tearing of tissues that happens when you have any kind of a physical injury, and the extent to which it's still bothering someone 6 months, a year down the road, when it doesn't show up on the medical imaging that we have today.
Gotcha. Number 3 about chronic pain is this, James, insurers often deny chronic pain claims despite that support from a doctor.
Yeah, they're really not going to dig deeper than that if they have the basis to say that there isn't any proof of your injury. If you're talking about chronic pain, it is very commonplace to see claims handlers deny simply on the basis that there isn't objective medical evidence. The smarter claims handlers are going to avoid using that specific language. They'll say that we just don't find that there's sufficient evidence to support your claim, as opposed to outright saying there's a lack of objective evidence.
Right.
But at the end of the day, we know exactly what it means. And if your doctors, if your treating doctors, your specialists are telling you that you have chronic pain and that your pain is preventing you from being able to do your job, then you're entitled to your benefits.
Next question we get asked all the time, we'll tackle it after the break, is will you get LTD coverage if you suffer from COVID-19 long-haul symptoms? That's a big one. We'll get to that after a short break. In the meantime, guys, the number 1-855-821-5900 and help at disabilityrights.ca. Stick around, more disability law shows coming right up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Thank you so much. Disability Law Show continues. Few minutes to go, guys. I mentioned earlier on the show another place for you to ask questions anonymously, freely, is mydisabilityquestions.com. That's a beauty because it's got a searchable database. That's the way the algorithm was put together. So you can see if a question similar to yours has been asked previously and answered by these guys, or a member of their team, mydisabilityquestions.com. And from it, fellas, we'll get to Danielle. She says, after contracting COVID, my brother is currently seeking medical attention at a clinic. For individuals with long COVID symptoms, his treatment provider has cautioned him that many people with long-haul symptoms have been denied LTD, and now he's worried about applying. What should he do?
First of all, kudos for Danielle for contacting us.
Yep.
We often have relatives of people who are owed LTD contact us because the individuals themselves are just too weak or frail or just are unable to or feel intimidated. So Danielle, the answer is very simple. Your brother should 100% apply and not be afraid of being denied. Now, have insurance companies denied people who have long-term COVID or long-haul COVID symptoms? Yes, but so have people who have suffered from cancer and people who are depressed and a whole myriad of other illnesses and injuries. Insurance companies don't discriminate. They may have tried to deny more long-haul COVID symptoms individuals than others recently, but that's because we've just gotten over COVID, or at least we've just gotten over the period where COVID was so prevalent. But that does not disentitle him from LTD benefits. It comes down to something fundamental, which is this: if he cannot work because of symptoms, be they from COVID, be they from another illness or something else, and his doctors confirm that he cannot work, the insurance company must approve the benefits. If they don't, he has a claim. Those are the kinds of claims that we deal with every day, and we've dealt with a lot of COVID-related claims in our office successfully. These are not difficult claims, but insurance companies, again, are trying to figure out a way to stop all these claims, right? Because they're bleeding money. And they're bleeding money because they've insured all these individuals and various employers who provide these policies. Well, they've collected premiums. It's time for them to pay up. People need that money. They need that safety blanket. And by the way, many of these individuals do eventually go back to work. So we're not talking about claims that go on for years and years and years. But regardless, you have to evaluate these things on a case-by-case basis. And if Danielle's brother is in fact disabled, COVID or otherwise, whatever the reason is, his doctors confirm it, the insurance company will pay or else.
I'll tell you, John, my experience is that at the adjuster level, when you make the application, Danielle's right. The information she has is correct. Insurance companies routinely deny long COVID claims. It is their go-to response. They see COVID on there and they deny it. Nope. So you may be asking, well, why the hell are you telling me to apply if they're just going to deny it? And the answer is actually really simple. And it's sort of the inverse of that. The reason that they deny at the adjuster level is because they know if they start approving claims, then everybody who has long COVID is going to start applying, and they're going to be paying out millions of dollars in benefits that they'd much rather not. So they want it out there that, oh, if you have long COVID, you're not going to be able to be approved. But the other side of that is as soon as they deny and you bring a legal claim, all of a sudden, the insurance company has a very strong vested interest in preventing that claim from ever seeing the light of day in a courtroom.
Really?
And the reason is simple. If there is ever a case that goes in front of a judge and there is a decision, that decision is public. And the first time there is a disability case involving long COVID that's decided by a judge, the instant that verdict is released, it is going to be published in every newspaper, every news outlet across the country, and every person who thinks that they have long COVID is going to instantly apply. So insurance companies, when they see those claims coming in from long COVID, they run for the hills. They want to resolve it as quickly as possible. So if you have long COVID and you've been denied, please do not give up. Give us a call.
And with that, we're just about done for the day. You heard it from James. Never reach out in any matter to reach out to these guys and at least have that conversation. That phone number, 1-855-821-5900. Email address we use is help@disabilityrights.ca and mydisabilityquestions.com. Again, free and anonymous. It's searchable, and that could be a very useful tool for you as well. And that phone number one more time, 1-855-821-5900. We'll catch you next time on the Disability Law Show. Thank you so much for watching.